Good morning, everybody. We are still missing one speaker in action, but we thought we should start already, and she can join as and when. The channel that we'll use for the headphones is 2, it seems. You're on 1. Well, I'm on 2, so that's very bizarre. Try 1 or 2. My name is Anja Kovac. I work with the Internet Democracy Project in Delhi. And I would like to first of all give you a very warm welcome here early in the morning in Baku, Azerbaijan. I think the question we want to address today has relevance for the situation in this country as well. The workshop kind of came out of the observation that there is a growing inclination on the part of governments to interfere in the internet. I think that tendency has been given some attention for quite a while when it comes to more authoritarian countries, but we increasingly see that this is the case in democracies as well. For a long time, I guess, the fact that democracies wanted to do this wasn't really seen as problematic because somehow there was an assumption that the criminal law in democratic societies, by definition, would be more or less unproblematic, I guess. Increasingly, it's clear that that is not the case. My organization is doing a study in India that looks at how the translation of criminal law that pre-existed the internet, how the translation on the internet actually leads to a stifling of freedom of expression that didn't happen earlier. Colleagues from Nepal and Bangladesh are doing the same kind of study in their country. One of my colleagues is in the room, Baburam from ISOG in Nepal. So I guess that is one dimension of the whole problem. But the other issue is that even if that criminal law is acceptable as such, increasingly we do see that there is a real tension between applying those laws consistently on the internet as one would have done before, and maintaining the free and global internet that we all hold so close. And so it seemed as if it was time to get more into the debate of what exactly are then the challenges that we are facing here, and what are ways in which we can resolve this tension, or perhaps solutions are too ambitious to aim for, but at least alleviate it, and in some way find productive ways to go forward. Our workshop today will be broken into several parts. We will have 3 sections. The first one will be smaller, and then 2 somewhat bigger sections, and I will take 1 or 2 questions after each section. And different speakers will address the different questions as and when they have comments. I'm very happy to have a very rich group of speakers in this workshop today. Let me start from my very right and your left with Ella Flynn, who is the head of public policy for Google in New Zealand and Australia. Just next to me is Moez Chakchuk, the CEO of the Tunisian Internet Agency. Paul Fehlinger from the Internet and Jurisdiction Project. And to my very left, Carlos Cortez for the Center for the Study of Freedom of Expression and Access to Information at the University of Palermo in Argentina. The person who we hope is still coming, I hope nothing bad happened to her, is Gillian York, who is the Director of International Freedom of Expression at the Electronic Frontier Foundation. I would like to start by just asking this broad question of why does the internet actually pose a challenge to the application of criminal law in different countries, and what are kind of the histories and the sensitivities to lead to that problem? And maybe a good way to get into that conversation is by looking at the innocence of Muslim videos, which had such a different treatment in different parts of the world. Irla, Google has been very intimately confronted with some of those contradictions. What was your experience of that whole discussion?
Well, thank you very much. This was a pretty difficult and complex situation dealing with the Innocence of Muslims video, which appeared on YouTube recently. The first thing I want to say is that our view is that we want YouTube to be a community that everybody can enjoy, as well as a genuine platform for free expression, and those are the values that we hold very, very dear. But this can create challenges, because what's okay in one country can be deeply offensive in another country. On YouTube, we have a system of community guidelines, which is essentially a set of policies for what is okay and not okay on YouTube. The system operates on the basis of complaints. So if a person sees a video they don't like, they can flag that video, it will be reviewed, and if it breaches the community guidelines, it will be taken down from YouTube globally. The Innocence of Muslims video was found not to breach those guidelines. And I don't know, who has actually seen the video? Has anybody in the audience seen this video? Okay, not many. Yeah, and I'd be interested to hear people's reactions to it, but we did make the decision is to not breach the guidelines. So that's point number one, but there's also the framework of law in different countries. And for countries where we have a local YouTube domain where we've launched YouTube, if we receive a valid court order or other proper legal order, we will block that video in that country. This is what happened, for example, in Indonesia and India. Those processes went on, and the video is blocked in those countries. But for countries where we have not launched YouTube locally, so it's on the .com domain, we will not block videos in response to legal requests in the normal course. However, we're very, very sensitive to the safety of the public, and if we do have credible information that a particular video is creating an imminent risk to human life, then I think we're faced with a quandary, and in those kind of exceptional situations we are prepared to block in a country, and that is the situation that developed here in Egypt and Libya, for example. So we did temporarily block the video in those countries that it's since unblocked. And I think it's good to kick off with this, because in a way it's a good case study of the difficulties that, on the one hand, an open and global internet, which is what we feel very passionately about, can clash with local community views and norms and indeed laws. These can be very complex decisions, and can be hard to make the right call, but I think that's a good example, and a good recent example of the kind of issues that we face with. So happy to come back further on that.
Well, Moez, from the perspective of the Tunisian government, would you agree that that was handled well?
No, for sure. I think that in Tunisia, as well as in different other Arab countries and in the region, we dislike these videos. But this is not the only video that harmed us. It won't be the last video that will also make us in a bad situation in terms of blocking or not the contents. We have faced different contents in YouTube and in Facebook during a year since the revolution. We have faced blocking pornography. We have faced blocking a lot of pages in Facebook, and all those issues showed us that we don't need to block anything. We don't need to block, because when we block, we increase the popularity of this content. I really dislike these videos, as well as different other contents in the internet, but that doesn't give a reason for the government or for a court or whatever, or for a lawyer to claim to block any content on the internet. We know that in Tunisia, everyone in Tunisia should understand that there is no freedom without being responsible. And responsibility comes with maturity, and that requires education. This is the key issue, I think. We need to educate people about how to deal with those contents. It's not a matter of saying, okay, we need Google to block any content in YouTube to be able to not be offended on the internet. It's not a real solution. As well as for pornography. We don't like the pornography for sure, but we defended that the internet in Tunisia remains open, and free for any filtering process. You know that the agency, I'm CEO of it, has a long history in blocking content, so we know very well how to deal with these issues, and we don't want to be backwards to those things. Thank you.
Moritz, if I can ask a follow-up question.
Yes.
Do you feel then that Google should have pushed back more in Egypt and Libya, where they did not have a court order?
I think that Google is in the wrong way to deal with those issues. I'm frankly speaking, I think that Google cannot really decide decide whether to block or not according to a court order. A lot of Tunisians don't agree that Google or Facebook or Twitter or whatever took control of some content in order to protect ourselves. We are mature, and we need to be mature in order to say, okay, if we need to block, we can apply for example, parental control softwares or whatever. You know, but not Google to block in or Facebook to block in a global manner.
So you're saying even when there is a court order?
Even when
okay.
And we try to avoid that we have court orders asking for blocking. We try to sensibilize, or to say, the judges to not order the blocking things, because it's not feasible first, and other thing is not real solution for those contents.
It's clearly a very different perspective coming from a government here, which is interesting, I think. Is there maybe at this point a question from the floor or a comment before we move into the issue of the bigger challenges? Now this is going to be tough. Let me ask Nigat first, and then Guy, you'll get the floor as well, but if you could both keep it brief, that would be great. Can we have a mic, please?
Hi, my name is Nigat. I'm from Pakistan. I work for an organization, Digital Rights Foundation. It's been 3 months now that YouTube has been blocked in Pakistan. My question from Google is that why they have temporarily blocked this video in Tunisia and Egypt, and why, in Libya and Egypt, and why they didn't respond to Pakistani government. I'm not asking that, I'm not in a favor of blocking content. I'm trying to know the process they adopted. This one thing. Another thing, that you said that you had Google had a fear of losing lives, and that's the reason that you temporarily blocked it. In Pakistan, due to that video, 7 people were killed. So why there is a discrimination in this process? And I mean, we are in a limbo. We are asking our government to unblock it. They are not doing it, and it is actually giving so much power to the government to block, content in Pakistan. And the blocking and censorship, ad hoc blocking and censorship, is so common in Pakistan, and we have no idea that who to contact with. Google is not responding. Pakistani government is not responding. So where the internet users go and ask for the grievance. So that's my question. Thank you so much.
I think some of the later points about where users go will be addressed later as well, but it's already interesting to see a government request Google to intervene less, and an activist ask, why didn't you intervene in our country? Ela, just before you respond, maybe Guy can ask his question as well, and then we can take them both at the same time.
Thank you. I'm Guy Berger from UNESCO. I just want to ask a technical question. Are either of you or anybody else aware of circumvention technologies to get around the YouTube ban, to actually see the video in these countries where it was either blocked by the government or by Google itself?
On the circumvention technology, I don't know in that particular case. Of course, we all know that such technologies are widely available, and people do use them. I often think that that avenue is open to people who are more technically expert and who understand how these technologies work, but are probably not a solution for, if I can call it, the average or typical internet user who will not have that level of expertise. So I believe that does go on. It goes on in many countries which have censorship systems, And I've also heard yesterday that governments are starting to focus on this and develop technologies and programs to block those kind of. So we're into sort of a game of cat and mouse. I will try and find out more details for you. In response to the questions about Pakistan, look, that's a very tough situation, and you know, we're faced with dealing with these things in real time, if you like. A situation is developing. We're doing our best to try and get information from the ground about what's actually happening. Sometimes it can be difficult to establish a link between a particular video you know, is contributing or is a big factor in a particular situation on the ground. And people may claim there's a clear linkage, and that may be true, or it may not be true. It can be difficult. I wasn't involved directly on the ground, so I don't have that specific information. Maybe we can talk later about it. But as I understand it, the view from our people on the ground and different contexts we have was that the situation in Egypt and Libya was slightly different to Pakistan. You may disagree with that, but I think that those were the drivers. And you're right, of course. What's happened is YouTube is blocked in Pakistan. We're frustrated by that. All the people who use YouTube, I would imagine, are frustrated also. It's not a good situation, but it's very difficult. What is the path out of this? Should YouTube just block this video and have the service restored, or is it possible to work with the government and others to try to resolve the situation? Not easy to navigate your way through these things, but I think we do believe that there are situations where you know, blocking material in certain situations will get us on a path where we will end up censoring very, very heavily. And sometimes we believe we have to draw the line. Similar situations apply in other countries. We've had a long running situation in Turkey, for example, where YouTube was blocked for a long, long time. Similar situations in China. So I think none of these are black and white cases. They're very hard calls to make, and very interested to hear more from the audience and the panel on the right way to navigate through. But that was the situation in Pakistan, which we felt was slightly different to the other countries.
Just a comment for Google, and you know that YouTube have been blocked for years in Tunisia by ITI, and this is just because one of two videos talking about our dictature. So after the revolution, the last decision of Ben Ali was to say, okay, we open YouTube before he flowed out to the country. So YouTube, I think, is something that we need to be remained open for all countries. Thank you.
I think what this setting of the context has already done is just show how complex this is from different perspectives and different local contexts. Carlos, could you perhaps say a little bit more about where exactly do these challenges come from here, and why is this so much of a problem?
Thank you, Anja. Well, I think that the most important challenge to bear in mind here is that criminal law, in a general sense, whether if it's to tackle copyright infringement or to tackle the problems of the case we were just discussing, ends up working in the digital environment as an incentive towards closeness and control. It's an immediate effect of this sort of regulation. So if we're talking about the open internet and criminal law, I think we have to start from the point of how is criminal law driving changes in the internet, both in the code and in the content layer, because it's clear that a law, any kind of regulation, will end up driving the way coding is done and will have a direct impact in the digital environment that we use. This is a concept, an interesting concept that some authors have explored, that is sometimes called architectures of control, which is also sometimes called architectures of confidence, where there are configurations that end up defining to a very detailed fashion what a person can do online. And we see it specifically in the in the structures or regimes of authorization, where I have to have my identification, where I have to clearly be what I am in the real life. I have to be the same person in the digital world. So I think that's a huge challenge for the open internet. We're facing not only just a separate group of laws that end up impacting conduct, but we are enabling a totally different environment of social conduct online. And I would take it from there to say that it's a challenge that cannot be analyzed case by case.
I presume that has very important consequences then for users. Could you maybe talk a little bit about those as well, Carlos?
There's an interesting thing about how this ends up impacting users, because we're many times just focusing on what the internet is not allowing us to do. So we talk about the changes in the internet. So I cannot access YouTube now, or I cannot access this service as I was able to do it some time ago. We nowadays cannot download music. Some of us did it 10 years ago. I mean, people did a party or did a whole record with Napster songs. But there's an important issue to bear in mind about what the conducts are being enabled to do. I mean, what is this new environment allowing us, or more or less incentivizing us to do? And I think there's a challenge over the normalization of certain conducts. So to the extent that we are identified users, to the extent that we feel monitored, to the extent that we have to respond or to bear in mind serious legal challenges or risks, we are going to start driving us to certain kind of conducts that are more or less expected from us. So perhaps we are going to think about what searches we are doing in an application as Google. We are start to see exactly what's our history in navigation, because it's something that will impact definitely our way of behaving. And I will just close this saying that this is something that some scholars, like for example Julie Cohen from the US, defines as a way of building sort of a panopticon discipline in the internet, like just using law, using certain structures to build a way of surveilling the individual online.
I guess that's a perspective from the user. In a way, though, that is true of users across the internet. I mean, some of those new architectures of controls, I guess because they come out of businesses as well, are put into place cross-boundary. Criminal law is often more specific to a specific country. Paul, could you perhaps say a little bit more on the issues of harm that is exported from one country to the other over the internet because of the application of criminal laws?
Yes, thank you very much for having me here. I think the general tension that we are seeing and that we already talked about is due to the paradox that the internet as such is a cross-border architecture. It is not a borderless architecture, it is cross-border, whereas our Westphalian system of states relies upon the notion of geographically physical separated borders. And this is at the root of all this tension that we are seeing. If you talk about criminal law, you see that there are certain globally accepted standards and norms, for instance on child pornography. However, the conception of what exactly constitutes a crime can differ among jurisdictions. And as states increasingly assert their jurisdiction also online in cyberspace, we see the impact of this tension. For instance, if blasphemy is a crime in one jurisdiction and not in another one. But it's not only this tension, but there's also another trend. Things that were not criminal before are now being declared as a crime in some countries. For instance, if we talk about cyber travel, Russia just drafted a law that would ban or criminalize the use of proxies, whereas, for instance, in New Zealand, there's an ISP that offers New Zealand users or customers the right by default to travel virtually in the US jurisdiction and use Netflix. So we see an emerging patchwork. And part of this patchwork, on the one hand, we have this patchwork, but on the other hand, we also have growing transboundary impacts due to the assertion of national jurisdiction over online activities. So it's not only crime that can have impacts across borders, but it's also the assertion of jurisdiction of states by law enforcement agencies or courts, or also in the sense of prescriptive jurisdiction, that can have transboundary impacts. To take one example that we did not talk about yet, or that was evoked by Carlos, is criminal copyright. So you see a tendency in criminal law, historically, a lot of our international jurisdictional standards are rooted in criminal law, in cross-border in cross-border crime. So it's either where the user is placed or where the effects are felt, where states can assert their jurisdiction. However, in the case of criminal copyright law, we saw this year a lot of cases that point to another direction. If you think, for instance, about the Rocha Directa, I don't know how many of you have heard about the Rocha Directa case. Oh yes, some of you did. So the US Customs Enforcement seized a domain that was registered in .com in the US of a site operated by a Spanish guy that was not declared illegal in Spain. However, as it was operated under a .com domain, the US could assert its jurisdiction under criminal copyright charges and seized this domain and only released it a few weeks ago without further explanation on why they did this. And to give you another example, all of you, I assume, heard about is the seizure of Mega Upload. So there again, you have the case where you have a cross-border platform that is operated by a German national who's residing in New Zealand, who's operating a company that is incorporated in Hong Kong. However, he uses a US registered .com domain, and he uses servers that are located in the Netherlands and the larger part in the US. So what the US did there as well was to seize the servers and the domain and asserted their jurisdiction over the servers and the DNS. So on the one hand, you have cases that are pretty clear in terms of criminal law on the internet, where you have, for instance, a French guy who uses a French service that is registered under a .fr domain and interacts with content that is stored on a French server. It's clear this is a matter, if he commits a crime, it's a matter of French jurisdiction. But for cross-border online activities, most part of those activities involve simultaneously a lot of jurisdictions. And this poses a problem to the Westphalian system that is the basis of our global order. And this creates transboundary impacts, especially via the servers and the DNS.
Thank you, Paul. When we were having a conversation earlier, you did also mention that the way these challenges are spreading is not just because of the behavior of states. Companies do also play a role in this whole area as they increasingly cooperate with law enforcement. Could you say a few more words about that as well?
Well, cross-border online platforms are in a very difficult situation because since they constitute a sort of horizontal layer, whereas our jurisdictional Westphalian system is based on separation of boundaries and vertical normative orders. Those companies span across multiple jurisdictions, so they face the challenge to respect the multiplicity of 192 plus different local laws and respect their sensitivities. It's not only about laws, it's also about local sensitivities, and to respect them in their terms of service, as we saw, for instance, with the fact of blasphemy as a crime and the Innocence of Muslims video. So increasingly, I think you could say that those cross-border online platforms constitute a sort of digital territory, and the terms of services are increasingly morphing into something. We had a workshop a few weeks ago at Stanford University where we had major civil rights organizations like Electronic Frontier Foundation and Privacy International, but also a lot of US-based cross-border online platforms like Twitter, Google, Facebook, Microsoft, and so on and so forth. And I would like to share with you a very interesting expression. So basically the terms of service for at the early days when all those companies were still small startups, were sort of cover your ass policy to exclude those companies from liabilities. So it was just someone, they hired a legal expert to just draft something in order that they cannot be sued. But at that time, those were small companies who operated in one country who didn't have an international user base, where the users are citizens of multiple jurisdictions. And they increasingly morphed into something that one could call, or that someone called, accidental constitutions. And that was something that Iyala mentioned before. For instance, in the case of the Innocence of Muslims video, Google faced a very difficult situation because they received a lot of different requests from various jurisdictions, from various agencies, in very heterogeneous forms. So just a request on a piece of paper. And they had to judge whether this was a valid request, whether there was a valid legal basis, and whether the person who asked for the takedown of the video in a given jurisdiction had the authority within the hierarchy of his state or her state to do so. And this is not a scaling problem. The answer to this problem is not that you just hire more staff in order to process all those requests. That would not be a major problem. The problem is that this is a qualitative problem. Yeah.
Thank you, Paul. I think some of what you pointed out, this idea of terms of service as constitution almost leads to a new level of law we will be faced with to deal with the criminal law of different states. It almost sounds like that, which is more of like a centralization, one could say. Carlos, I think you also have been commenting on how the fragmentation in terms of criminal law might lead to forum shopping when it comes to accusing people of different crimes.
Well, the background that we have in Latin America right now is, I wouldn't say a trend, but perhaps a series of cases of defamation conviction against journalists in different countries of the region. So perhaps the most famous case, and some of you might be aware of it, was the conviction against a newspaper, a director of a newspaper in Ecuador, for defamation against the president. So the risk that we might be facing right now with taking the defamation, this kind of criminal law to the internet, is a forum shopping, because while we have some countries in the region that have decriminalized defamation, most of them haven't done it, or they have it under very general conditions, as happened in Argentina, as happened in Colombia. We have also a case. So that might be a risk that might be unfolding with a problem of jurisdiction, as Paul was saying.
Before we move into the third section of the workshop, I wanted to see if there's any questions of the floor, but also check, Irla, if you perhaps want to respond to some of these things, because I do think that Google comes up quite a bit, so you should get an opportunity to react. And also, Nigat, I don't know if you felt that your question about where can users go with this process was answered? Okay, so maybe that's a bit you can also still take up.
I suppose, first of all, ultimately, I agree with what Moa says, which is that in the long term, a key issue actually is for individuals to understand better how the internet works and the way it operates, and in a way for governments to play a positive role in leading that process, to say we can no longer control the media, you know, the way we claimed we could control it in the past, you know, when there were just 2 TV stations and 3 newspapers, you know, in our country. We've now got this new technology called the internet. It allows access to global content. Yes, we will find some of that deeply offensive. Yes, some of that will break our law, but governments should not say to their people, we can protect you, we can block all the bad stuff, because that is just not the case, okay? So I agree very much with that point of view. But that doesn't stop, you know, a very difficult situation arising. And I suppose the question, if you're running something like YouTube and you have a request, say, to block one video in a country, if you block it, then that video will disappear, but all the other videos will be available. But you may see that as being on the slippery slope towards censorship, because maybe there'll be another request tomorrow, and then there'll be 100 requests, and then 1,000 requests. The other option is to say, no, we don't regard this as a valid request. We want to keep this information available to all the people who use it, but then you can find your whole platform blocked, and then no one in that country can access anything. So it's a very difficult choice, and in a way, neither of those options are particularly good. But we have been prepared, and Tunisia is another example, to say no, to have the entire platform blocked. And to suffer the consequences. But remember that it's, you know, YouTube is providing the platform, it's users who provide the content, and it's other users who want to view it. So there's a broader question of shared responsibility. I'm sorry if you felt that YouTube was not contactable. We will have to do better, and maybe we can talk later on and figure out how we can work better in those kinds of situations. So does that answer the?
I think for now it does. Sir, please go ahead. Can you pass the mic, please, to the gentleman behind the remote moderator?
The microphone is there.
Oh, Guy, can you please pass on the mic? Thank you.
Okay, thank you. My name is John Duff. I'm from Tanzania. I would like to know why there is no international agreement or convention on cyber crimes. Like, well, I know in Europe they have the cybercrime convention, and in Africa they are developing a more similar convention, a regional convention. So my question is, why don't we, the international community or the UN doesn't come up with an international convention, at least to those agreeable standards that, like, child pornography is a crime per se. So we have an agreement on certain crimes, that these are crimes that can be committed on the internet, because the internet has become a facilitator of commission of crimes. Thank you.
Carlos?
No, I would just answer that question from the perspective of the inter-American system, and I would give you a short answer. We would have, I think there's no convention because we would disagree in a lot of points on how should we move forward. And just to give you an example, we have a guarantee of no prior restraint. So much of the problems that have been solved in other jurisdictions have been solved by removing content before it has been acquitted before a judge, or before due process has been held to a certain extent. And that's indeed a problem, for example, in adopting some of the proceedings that the US has on copyright removal of content. So I would say it's better not to have it right now from the perspective, because I like, and this is of course my personal opinion, what my framework has in my region that one other region might bring to the debate if they are to push forward a convention.
Yeah, for sure. What I mentioned before is that I totally agree that the approach to be held in Tunisia, for example, in other Arab countries, is just to educate people about the internet. But at the same time, when we start and we give a solution to the government to control a content or to be able to delay the content one time, it won't stop. We know it very well. We experienced the same thing with our censorship machine in Tunisia. It's a very efficient one, you know very well. We spend a lot of money on it, but it's not good. And at the end, we found it inefficient. It's supposed to be more efficient than that. And I think it's better to say no to countries today according to their national regulation. But you have to know something that in most of those countries, there is a big gap in their regulation. If you focus on the case of Tunisia, we know that we don't have nothing in our jurisdiction about internet and about cybercrime. We have some few texts, decrees, and minister decision, but there is no global framework about cybercrime in Tunisia. And so starting to censor or starting to apply for this regulation by Google or by Facebook is really worrying us, because you know that you know very well that if internet is open in Tunisia, it's not because of the government. The government wants very well to block the contents, but it is because of the netizens who asked for that, because of the advocacy that had been done for many years. And you know very well that that Ben Ali prison put in prison many dissidents, and some of them were died because of that. So you are not expecting government to protect net freedom. It is the whole citizen, all citizens that have the real obligation to do the mandate. But government had to support that in order to promote human rights and to promote an internet as an open platform for promote democracy.
Yes. Hello, my name is Jonathan Zook. My name is Jonathan Zook, and I'm with the Association for Competitive Technology. I'm curious about this tension between an open internet and criminal enforcement, and it seems like it's very easy to have the conversation in the context of defamation, freedom of speech, etc. But the very same advocates who are working toward an open internet are the ones that worked so hard to bring about, for example, consumer protection laws inside of so many of these jurisdictions, to make sure that companies couldn't sell cars that would blow up, or food products that had bad ingredients in them, etc. So the same advocates, the same advocates on behalf of consumers that are now crying for an open internet were also the ones advocating for consumer protection. And so let's have the more uncomfortable conversation, which is about enforcement of laws that are designed to protect consumers, not from religiously objectionable videos, but from products that might harm them, etc. That many jurisdictions have fought long and hard to put in place in the first place. How do we reconcile that problem, which seems to me a little less comfortable conversation to have?
I saw one more question there in the back. Let's perhaps take that immediately as well, so that we can answer both before we go into the last bit. I do think that's a legitimate question which you just asked, and it very much feeds into the same question of why is there no global...
I'm here thanks to the initiative Web of Tomorrow is Yours. We represent young people from Europe. Do you hear me? Okay. My name is Viktor from Hungary. I'm come from a country where there is now a proposal of internet blocking, and there are three main categories: the child abuse online, the criminal act against state, and the danger of terror. Could you, like, one by one give me a definition of terror? You know, if the national security, I mean, if I'm looking, I don't know, angry, that I might be, you know, dangerous for someone else. So I see that internet, as you also mentioned, is really a global place, and now governments were elected to run a country, but they were not elected to run the internet, which is on another level. It has another layer, but still they see. I mean, Google had agreement with the German government to filter 120 terms on Google search. Russia and other countries. I mean, this is a common behavior now, we see. So other governments also think like, see what they do, we can also do something. And blocking doesn't have just like for the mainstream users, yes, but internet is interconnecting things. So if you block one connection, there are so many other way around. So I think governments still now experience, and then the way you let them do it, as long they can go farther and farther, like a child, you know, if you are not consequent enough, they will go like run the whole family life. Thanks.
So in Germany, the availability of Nazi content or Nazi promotion content is illegal. We have localized services in Germany. We comply with those laws. If you search in Germany for, you know, a website that has that kind of material on it on Google search, chances are you will not find it. What we do in those situations is we try to inject an element of transparency. So we will put a notice on those searches to tell you what has happened. Under German law, some search results have been removed, and we offer a link to the Chilling Effects website where people can find out a bit more. So that's the kind of system we operate. But look, these are really good questions that people are raising. I think, you know, and so we're getting on to how do we get good public policy outcomes here, and how do we get outcomes that protect the openness of the internet. I think as a starting point, I'd suggest it's really important to frame the debate in different countries in a positive way, because if the internet is seen as this alien thing, this foreign technology, you know, that's coming into my country, and it's bringing with it sort of values and content that are deeply offensive, then that will underpin you know, a debate that's driven by controversy, that can be led by, you know, sort of shrill reporting in the media, and we can end up in a bad place. So I think there is a job for all of us to do in all countries, which is to highlight the positive impacts that the internet has. And sometimes that is, for example, the positive economic impacts, because if a government sees the internet as purely this kind of, you know, this revolutionary platform for political commentary, then they may take one view. But if they can see that, for example, it's an engine for positive social or economic impacts, then that can be important to frame the debate. And if we can frame the debate in the right way, we may get to better points. You know, I've plenty more to say in terms of driving a good policy, but I again go back to what Moaz said earlier. I think educating people about how this actually works and the benefits that it can bring is really important. I also think that mobilizing civil society in different countries and different partners to take these issues to their own government is really important, and that is something we try and do in many countries as well. So I think there are a lot of different elements, but we can win this debate long term. But I think we have to think clearly about the impact in different countries and how to frame the debate in the right way.
Victor raised a very interesting point, which is the cross-border nature of the internet, and that was also what Jarle highlighted. I would go even a step further. I would say that the internet is not only a cross-border infrastructure, but it is a common shared infrastructure. It is a global commons. And we all are aware of the benefits for mankind that this infrastructure, that is a global commons, has brought to us so far. However, the tension that we are currently facing is due to the fact that our Westphalian system and our jurisdictional system is based on the concept of separation. Managing a shared cross-border infrastructure means that we need to understand how to manage commons, because there are trans-border impacts at all instances of cross-border online activities. So this management requires a sort of cooperation and co-responsibility, but not only between the different governments, but also this is a multi-stakeholder challenge. So this requires cooperation by the states, by the platforms, the cross-border platforms, and the users.
I would like just to raise a couple of points regarding the first question. I think it's really crucial what you say in terms of what I was mentioning at the beginning, and it's that perhaps many of us are not aware that the changes in the internet also mean reconfiguring the social space we live in. I mean, that means reconfiguring the commerce, our social relationships, education. So up to some point, we're perhaps very focused on how on this concept of the internet while not grasping the whole complexity of it. I mean, e-commerce, security of people, users is also a crucial point in that specific area. And I think that's a problem on many advocates of the open internet. And I don't think I have the answer to that question. And it's how should the open internet look like? So we're perhaps defending an ideal of the open internet, but perhaps we don't know how that open internet should look like if it was to address all the concerns we have. And a small point regarding terror, I think we should bear in mind the clear problem of the rhetoric of fear, of pushing criminal law or pushing regulation in different aspects of life, and that rhetoric of fear is something that is definitely driving an important debate in the internet. So you can see it. I'm currently living in the UK, and the rhetoric of fear is crucial. For example, to push the CCTV programs, which are seriously challenged with very serious evidence if they really work, if they don't work, because it's also a business and it's also an ideological standpoint. So I think we should bear in mind those things when we are going to assess critically the criminal law that we're discussing for the internet.
I need to be back to, yeah, for sure. Yeah, for sure, yeah. I think that the government have to focus a lot on security, on national security, especially during the regime of Ben Ali. Yeah, and this is, I think, they lost a lot of opportunities, and this is our mandate today, together with private sector, to show them how many opportunities they lost, and that is the key issue. If we remain focusing on blocking and cybersecurity and comparing internet just as a threat, considering as a threat, we want to be able to take this opportunity and to develop the internet in Tunisia. So this is my comment about
it. I'm just, I mean, I think some of the comments that have been made are already asking the question of, so what is the way forward? Clearly there are certain concerns where perhaps criminal law and national jurisdiction still are the first way to solve those genuine concerns. Clearly there are issues that perhaps need a global solution, and that solution hasn't been given. I must say I really like Carlos's point that maybe the way to solve this, the starting point perhaps should be to rethink what we think of as a free and open internet and what that means. Maybe we've not been creative enough in thinking through what that is in the future rather than what it was 10 years ago. I don't know what the possibilities are, but I definitely think it's an important starting point. It could be an interesting thought process. I know that in terms of resolving that direction, the tension more concretely, Tunisia has been taking some important steps in the new regime. Moez, can you tell us a bit more?
First of all, I want to mention that Tunisia seeks for sure an open, interoperable, secure and reliable information and communication infrastructure. That's something that is a concern of, still a concern in my country. But we also, after the revolution, we say that, okay, we need to do reforms about the internet and about how internet is governed. So we open the door to civil societies, and we try to make a difference and to transform how people think about the internet. So it's not just regulation and reforms in terms of jurisdiction, but it's also go deep in their mind and people and try to explain things. So we started by the ITI. You know, the Tunisian Internet Agency is, let me say, is a historical part of the internet of Tunisia. It's the agency that was in charge of everything regarding the internet for years. So it's a mono-stakeholder organism or structure that was in charge of censorship, of surveillance, of internet development. But initially, it is an internet exchange point. Of course, we are not recognized by the other internet exchange point, as we don't have peering and we don't have applying the best practices. So after the revolution, it was for us very important to move forward and to keep the ITI, because a lot of persons or political figures and civil society asked to abolish the ITI. We had a lot of pressure also from different consultancy company who worked for banks, for the government, and try to advise the government, okay, to abolish the agency. But we kept in mind that if you abolish the agency, it is that you abolish or you destroy the unique internet exchange point in the North Africa region. We don't have a lot of internet exchange points, if you know. In Morocco, we don't have one. In Algeria, in Libya, and Tunisia, we have only the internet exchange point. It is ITI. So we advised the ministry at that time, since after the election, that ITI cannot play a role in cybersecurity. We are here for the internet development, so we need to keep our main role as an internet exchange point, and also work for the domain names development. That's it. So the government applied for that, and now we are dealing with a global reform for cybersecurity in order to create another agency or make a law regarding the cybercrime or something like this. But it's very, very worrying, because we need to keep safeguards. What is worrying me, you know, that Tunisia adopted the declaration of net freedom made by the coalition of countries, and we organized a net freedom conference in June 2013. So it's very opportunity for the government and for civil society in Tunisia to understand what is net freedom, and also to guide the government to put safeguards on the constitution and the other laws. This is our concern. You know for sure that ITI will move forward towards the internet exchange point role, but at the same time we keep advising the government to also go in the good direction, and to move in the good direction in order to prevent any violation of human rights, because we know that very well that internet couldn't be developed if human rights are not ensured. We experienced that for years, and internet in Tunisia lost a lot of opportunities. We know that very well. Thank you.
I think that was an experience from the national level. Carlos, you were earlier talking about how some of the changes that take place also normalize a new kind of behavior on the internet, which is part of that tension between criminal law and the free and open internet. Do you think that, for example, the Inter-American Convention on Human Rights is an instrument that could help push back against some of these things? Is that where one of the solutions lies?
Well, one of the things that we have been doing in the CELE Center of the Palermo University in Argentina is trying to explore these issues under the light of the Inter-American Human Rights Convention, and we have come to the conclusion that although we might not solve the problems, it's really useful to at least analyze them. And just to mention one point that might help, proportionality. Proportionality is a very important criteria to analyze any kind of regulation under the Inter-American Human Rights Commission. And I know we didn't invent this. I mean, this is something which is used in several legislations and judicial systems. But the point is that this has been key to analyze the way some criminal laws in physical space have been used to shield freedom of expression. So perhaps this might give a framework to at least level the playing field, to make the debate on how we should move forward in a regional way. And I think, to add and to end this point, this might also give some keys to other aspects that are not related exclusively with law, but might be useful as self-regulation processes. I mean, in this criteria of proportionality, of self-restraint, of criteria to make legislation, we might also find some ways to design self-regulation procedures that might help public policy, instead of just thinking that criminal law will solve problems as complex as the ones that Moez was describing.
Ilya, you mentioned earlier that you had lots of things to say about how to make good public policy. Can you say a few more things?
I hope it didn't come out that way. Well, it was very interesting what Victor, who is just leaving, Sorry, Victor. In terms of, we see many proposals around the world for filtering, for example, and very often they start with child abuse material, okay? And it's hard to argue against that, but I think we have to, because what we need for good public policy is we need a clear problem and we need a good solution. And very often, when you drill down into these kinds of proposals, it's not clear what the problem that they're trying to address is, or how this particular filter will actually solve it. Often these things are much more driven by political considerations or responding to media pressure. We need to ask those hard questions. We need to try and force governments to address those issues. Very often, if we get a filter that is initially narrowly targeted, this can very quickly expand. Okay, so first of all, it's child abuse material. Now, what about terrorism? What about very violent content? And suddenly we're on the road to filtering and blocking huge varieties of content. So it's really, really important to have the battle at the first instance and not let these systems get established. Look, another element I think that needs to be injected here is a realism about how the internet actually works, and that goes to the effectiveness of some of these systems. You block one video, well, maybe 10 or 100 or 1,000 other videos will come along instantly that will show the same. And Moaz is absolutely right. Sometimes the effect of blocking a thing can be just to make it more popular. Surely that isn't the effect the government wanted to have, but that can often be the effect that they will achieve. So governments need to understand how the internet works, and I think industry and civil society have a very important role to play here in terms of engaging with government in a rational manner to talk about these things from a position of saying, yes, there are bad things, there is bad content. We want a solution that protects the people in our country, but we want real effective solutions, not things that kind of look good and are just designed to kind of keep things off the front page of the newspaper.
Well, a line I've heard you use earlier, or a question I heard you raise earlier, Erla, was, are we making policy or are we doing politics? And I think that's often a very good distinction in this field. Unfortunately, a lot of it seems to be about politics rather than policy. Paul, I know that one of the solutions, I think, or ways forward you envision are standards that would apply not just across jurisdictions, but also across businesses. Would that mean that exercises that happen at the Internet Governance Forum, amongst others, of developing internet governance principles of various kinds, could be a way as well to push this whole debate?
Well, first of all, let me say it's not. Over the last 2 years, we saw a lot of internet governance principles emerging. And if you look at them, you see certain patterns emerging. And as you know, I'm working for the Internet and Jurisdiction Project, which is a global multi-stakeholder dialogue process on exactly how to address this tension between the cross-border nature of the Internet and geographically defined national jurisdictions. And we identified a certain set of shared norms that all stakeholder groups might possibly agree on as a result of our ongoing dialogue, which is availability, so the broadest possible availability of content that is legal, the respect of granularity, as we heard before. YouTube was blocked in Tunisia for a very long time just because 2 videos on the whole platform infringed Tunisian law.
Yeah, I want to mention that without any law, it is the decision of the Ben Ali regime. So it's not just because of one of the videos showed Ben Ali and okay.
To informal decisions.
Yeah.
But sorry for interrupting. Sometimes that situation can arise through legal channels also. That was the case in Turkey, where there were videos criticizing Ataturk. This is illegal in Turkey, so we had valid court orders, which we did not prepared to act on. And so, okay, but I'm just saying in some countries you can have a situation where it is driven by law. There is valid legal process.
And I think another very important principle or shared norm for all stakeholders is transparency. The transparency of procedures, exactly what we just had. We have on the one hand countries where we have informal requests by some government agencies or ministries, whereas on the other hand we have requests, formal requests by law enforcement authorities or courts. But those procedures are often not really traceable, not very well documented, and also not interoperable, because again, if you take the perspective of a cross-border platform, you receive all those requests from all different jurisdictions and all those diverse forms that we just heard of. So there's a lack of interfacing procedures between not only jurisdictions in terms of cooperation in online crime, but also in terms of the cooperation between jurisdictions and cross-border online platforms. And lastly, and this is a major issue, I think, is the need for due process. So really a clarity of procedures for takedown, for law enforcement, access to private identifiers or private data, and so on and so forth. Yeah.
Thank you. And I think in a way some of that also comes back to the question of the gentleman from Tanzania earlier. On some of these issues, perhaps we do still need to find the best platform to, on a specific issue, develop some of these shared norms and processes and et cetera, et cetera.
Well, that's a very good pitch. I would like to invite you because the Internet and Jurisdiction Project is hosting 2 workshops. One will take place this afternoon on frameworks for cross-border online communities and services at 4:30, and the other one will take place tomorrow at 2:30. There was a shift of schedule on the geography of cyberspace, so the overlap between physical territories and the cross-border nature of the Internet and the infrastructure of the Internet. So there is really a need for a structured dialogue on this, and I invite you all to participate.
Thank you. I already see 3 fingers. The lady here was first, if somebody can get a mic to her, and then Guy and the gentleman over there.
Thank you. My name is Tina Fraguli, and I'm from the RIPE NCC. Actually, I wanted to mention your point you just made, that because, okay, what is crime and what is not, it's a big, yeah, it's a big discussion. And, different jurisdictions, what's crime in one jurisdiction, what's not in the other jurisdiction. This is a discussion that has, it happens outside the internet too. It's nothing new, right? Of course, in internet, the cross-border element is there. So it happens more often, it's easier to happen. So, of course, the LEA, law enforcement authorities, have to cooperate. And, yeah, when it comes to, to clearly, to clear crimes, let's say, like pornography, child pornography and things like that, the private sector wants also to help. I mean, this is unacceptable. This is something that creates this sense of I have to do something. It's my moral duty, let's say. But indeed, we see that the procedures we have to adhere to are very poor. The legal basis is vague, is not good, and this leads to a lack of trust. And internet is cooperation, is transparency, is trust. So if the users see that, they'll move to a different platform. It's simple. They'll do something else. It's like the Pirate Bay. It's like, they'll move to different countries, to move to different jurisdictions. This is how it happens. So in order to get this trust, we need clear procedures and transparent ones, of course, and clear legal basis.
Thank you. Let's first take all the questions and maybe don't have responses, Guy?
Thank you. I just wanted to ask, it's Lala, Yala. Irla, so you follow the law in Germany and you take down Nazi or links to Nazi, but in Turkey you don't follow the law. So clearly you're bringing other criteria to bear as to when you will follow the laws or when you don't. So maybe you could just tell us a bit more about the kind of criteria that you do bring. Thank you.
The gentleman in the back.
This is a question for Paul. So you spoke about treating the internet as a sort of global commons as a way of regulating cross-border spillover effects. To me, that is not the most apt analogy, because the internet is clearly a transboundary phenomenon, but I don't think you can call it a classic global commons. I don't want to be pedantic about it, and perhaps this is something that will get addressed tomorrow on the geography of the internet, but the fact that it is fundamentally a territorialized system, which consists of physical infrastructure in places and users in places. And where I'm going with this question is that I think one of the things that gets lost in a lot of these conversations is that national communities, especially ones where you have strong democratic polities, can very legitimately make different kinds of decisions about what's in or out, right? And we've talked about Germany and Nazi content, and I think that's a legitimate decision. So I feel that some of these conversations need to move down from the global into the local, which is where democracy happens, which is where people do make choices about what kind of community they want to live in. And I think that the internet has to be reflective of some of those norms. So that's obviously very challenging, but something to chew on perhaps.
Paul, why don't you go?
Okay, so I will respond to both questions. I will start with yours. So what you just said is that the internet cannot be perceived as a global commons due to the fact that we have servers based in some jurisdictions. The internet can be very physical, consisting of cables and servers. I would say that the internet as such was not conceived as a territorial infrastructure. The internet as such does not know any physical borders. I'm sure this will be the subject of the debate tomorrow, and there will be plenty of room to debate all those questions. But I think what is important to understand is that the internet basically consists out of three layers. So you have what you just mentioned, the physical layer, which includes the cables and the servers and so on and so forth. This is very physical, and there are natural choke points, of course. However, a second layer is the logical layer of the internet, which is the numbering and naming system of the internet and the protocols. And they do not know any borders. This is a human-made infrastructure where borders have not been programmed into the internet. Of course, it is the choice of mankind to re-establish those borders in cyberspace. And you can argue that it is the legitimate right of states to do so and to enforce their national jurisdiction to the fullest on online activities. However, you would change the nature of the internet, and you would change the internet that we are accustomed to, and our children, you would tell at some point our children in the future and grandchildren about the internet that was once free and where different cultures were interacting online on a regular basis in everyday normal life interactions. But this is an open question. I'm sure this will be addressed tomorrow in more detail. And coming back to your question, you raised very interesting points. I completely agree with what you said about the lack of procedures, procedural interfaces, and so on and so forth. But I would like to highlight one special point, because you said, you highlighted the fact that there's a huge disagreement between different cultures about norms, about what is a crime and what is not a crime. And this is legitimate. However, the challenge that we are facing in relation to the internet is, and I argue it is a global commons, is to manage a common infrastructure. And a point that I raised earlier when I talked about the seizure of meager upload and the application of national sovereignty over the logical layer, so the DNS, but also the physical layer in terms of the server location, which is a question that is very important if you talk about cloud computing, is basically that you could say, and I'm provocative here, that sovereignty kills sovereignty. So if you think about it, the assertion of your national jurisdiction can have adverse transboundary impacts on the citizens of other countries, just because on your territory you have the servers of a cross-border online platform, or the domain that is widely used by the internet community because it has a nice ending is located on your territory, and it is your legitimate right to do so. However, what you provoke is a situation where other countries see this as a justification to do exactly the same, and they will start to also assert their jurisdiction to the fullest on the infrastructure of the internet. And if this is happening, your citizens will also feel the impact. Maybe it is in the form of limited availability of content, for instance, so that some services your citizens are using have been taken down by another jurisdiction. So this is what I referred to before, the notion of cooperation and the need for co-responsibility to manage this infrastructure and to address the tension between the cross-border nature of the internet and national jurisdictions.
Thank you, Paul. Ila, I think one of the questions was also specifically directed at you.
Yeah, the question of when a service is localized or subject to law in an individual country is essentially a pretty complex legal question, and it's around jurisdiction. I'm not a lawyer, but that can vary by country. It can vary by the type of service. It can vary by how and when people access it. But the kind of things that I think are significant into that decision are, number one, where is the data hosted for this service? And if it's hosted in the country, that can be a very significant factor in bringing that service within the scope of local law. Another significant factor is the domain that the service is on, whether it's a local domain or whether it's excuse me, a .com domain, which is a global platform. And a third factor actually for organizations is do we have a local company operating a business in this country? That can also be significant. And finally, I'd say the presence of local staff can be a factor, particularly when you're concerned not to have them arrested and dragged off to jail. And that's, you know, that's into more sort of pragmatic domain. So obviously companies have to be careful where you set up local services and where you set up local offices and where you have people.
Thank you, Irla. Any more questions or comments from the floor?
Just to mention that the Freedom House report, Freedom on the Internet 2011-2012, mentioned Tunisia and as a significant score change, plus 35. So it is really worthy to mention, and we still, thank you very much. But we are looking forward also to see Tunisia next year among the free countries. Thank you.
I'm very reluctant to sum up especially the challenges. I'm sure we haven't covered all, though we might have made a beginning. I do think what comes out very strong in terms of solutions is that we need much better processes to start with, both within criminal law as such, as well as with businesses, and far more transparency around these things. I also think to some extent, clearly, we need a new imagination and get more creative around what things could mean. And finally, if I may add one point which didn't come out somewhat to my surprise, that strongly, though I think Carlos hinted at it, maybe we also need higher standards. I think among civil society, when I have discussions with people from other parts of the region, increasingly I feel that the inter-American system in many ways is actually an example, and I find it really striking to see how the courts there sometimes give judgments which we wouldn't even think of being able to achieve. So I guess it fits both the imagination, but also the fact that we have instruments like the Universal Declaration of Human Rights, which actually sets standards which criminal law often doesn't live up to sufficiently, even in democratic countries and even in places where there is often a lot of acceptance around how things have played out. That doesn't mean we shouldn't stop pushing. Just very quickly before we leave, I wanted to ask all participants to just very briefly, one line or 2 lines, say what is the hope for the future?
Well, I would just say briefly that I'm a little pessimistic about how the debate's been unfolding, but I would say that the human rights framework is starting to understand how the internet works, which was something that Yale said, which is a basic thing. And if we manage to translate highly technical debates into the rights language, and if we manage to start making sound policy without just being grounded in the internet we knew 10 years ago, we might actually defend some sort of open internet that we have to start devising in a very clear way.
Well, I think we are faced with a general challenge that actually we have a 17th century framework which was created by the Treaty of Westphalia that is regulating how we coexist and how we talk about how jurisdiction is structured and how states function and how the global order is maintained. And to address this tension that the 21st century technology of the internet is creating, I think what we need to have is a structural multi-stakeholder dialogue process on how to move forward and how to manage this global commons.
But you didn't quite do it, but does that also mean advocating for the end of the nation state? Let's not get into that. Lois?
I would love to talk about this. No. It does not mean the goal is not to replace something, and the internet, I think, the answer to the problems we are facing is not the harmonization of all laws. That's an illusion. I think the emphasis that I would like to make is really on how to manage the global commons. So what principles do we need to establish to enable the peaceful coexistence in cyberspace, and what interoperable procedures do we need in order to maintain the internet, but also to regulate it, of course, which is needed to a certain extent?
Okay. I'm really optimistic instead of my friend from Argentina. I say that what Mr. Frank Laurie was supposed to be with us today, internet will prevail as open as possible. So we will do whatever to let it be like this and to prevail. Thank you.
I think, and yeah, you mentioned transparency as being really important. We agree. I just want to give a mention to a transparency report that we publish, where you can see the number of requests we get to remove content from different countries, and we think that's important to bring this kind of activity out into the open, just so people can understand what's going on. In terms of policy debates, we have to fight, and we have to fight country by country, and we have to be smart, and we have to win those battles, because that is really, really important. If we don't win those battles, what we end up with is a series of national and regional different internets, which will fracture this global commons that is so dynamic and so important. And yes, I'm very hopeful.
Great. Fight country by country, and perhaps all of us together as well across boundaries. Thank you very much, everybody, for being here with us this morning and for all the interesting questions and comments. A very special thanks, of course, to all the speakers and as well to anybody who has been on the remote participation. Thank you.